and welcome. My name's Alice Caird. I'm a partner at Timpany Walton Lawyers in Timaru, and I'm here to give my input on the Chamber's workshop about earthquake-prone buildings. Originally this presentation was designed to be in person, but as you'll know, we're living in challenging times, so here's my video presentation. What I was going to start by doing is just giving you a little bit about the legislative background to what we're dealing with. So the things that you need to know are that the Building Act and the Building Earthquake Prone Buildings Amendment Act 2016 are the two pieces of legislation that affect what we're doing and what we're talking about this morning. The other thing that you need to know is that I'll be dealing just briefly with some health and safety issues. So there's health and safety legislation we're dealing with as well, and I'll give you the reference to that a bit later. The background to passing of the amendment to the Building Act around earthquake-prone buildings was obviously the issues that we had subsequently to the Christchurch earthquakes and government concern about our building stock in New Zealand and whether that was earthquake prone and a risk to the public and to those working in those buildings. This isn't solely a Timaru problem. You aren't being got at by the Timaru District Council in particular. So I just want to make it clear we're not apologists for the Timaru District Council by any means, but and we're obviously completely independent, but I think it is important to realise that this isn't something that our local council has decided is a good idea. They are subject to the legislation just the same as everyone else is, and they have certain obligations. So they need to work through various processes and require building owners to do certain things within a certain time. What I'd suggest that you do is get as much information as you can about the current legislation, current timeframes, and what's required of you. And in that regard, there's a very good resource on the Ministry of Business, Innovation and Employment website, so the MB website, building.govt.nz. That's got some really useful written material, it has short videos, it also has online courses that you can take if you are interested in that. So that's a really good resource to look at. The Timaru District Council website also has various resources and links to websites from other organisations that you may find useful. So just taking some content from the MB website, the system for earthquake-prone buildings is consistent across the country and focuses on the most vulnerable buildings in terms of people's safety. It categorises New Zealand into 3 seismic risk areas and sets timeframes for identifying and taking action to strengthen or remove earthquake-prone buildings. Timaru is in a medium risk area, and so that risk area is used when calculating timeframes for assessment and remediation, and when the council is looking at what earthquake strengthening is going to be required. So the 3 areas New Zealand is divided into low, medium and high risk. So once again, Timaru District in that medium risk area. Now, timeframes in terms of what's required for your assessment and remediation, I'm sure have been given by the council and Davis Ogilvie in their previous presentations. But if you have any questions around that, again, I'd recommend that you get onto the building.govt.nz website or the council website, or just have a talk to the local council. Your local, the surveyors will also have some information about that, or engineers that are going to do your assessments. So that just gives you a brief overview of what we're dealing with in terms of the background. Now, there were 2 extra purposes for me being part of the workshop and the presentation. One was to touch on leases and what implications being required to do this work might have for either tenants or landlords under a lease, and also to touch on what issues might arise as a result of health and safety legislation. So perhaps if we turn to leases first, there are obviously various different versions of leases. Health and safety legislation and building legislation is the same for everyone, but the contractual arrangements between a landlord and tenant are going to be different and will to a large extent depend on their lease. Different versions of leases have different provisions, so it's important that you get out your current lease and you have a look through it and check that you're aware of its terms. What I've got with me today is the latest version of the Auckland District Law Society Deed of Lease. So I'm not sure, hopefully you can see this being held up, so the Deed of Lease form here. Now that 6th edition 2012 brackets 5 is the most recent edition of the Auckland District Law Society lease, or sometimes called the ADLS lease. There are other forms of lease that are used. I know probably primarily in the North Island, maybe Auckland, there is a property council version of the lease. There are also different leases that larger companies will have. They design their own. So if you've got a large national, multinational company, it's important that you get out that lease and have a look. Probably the ADLS lease that I've just shown you is the most prevalent in our district. That lease is updated and changed from time to time. So if you entered into your lease 5 or 10 years ago, and it's an Auckland District Law Society lease, it will be different from the current form. The forms are updated every, say, couple of years or so, or when there's a large legislative change. So it's important that you get out your lease and be familiar with its terms. If you've got any questions about your rights or obligations, either as tenant or landlord, then the answer to those questions will largely be determined by the terms of your lease. And if you are going to see your legal advisor, you would need to provide them with a copy of your deed of lease when you go in to see them. My practical advice here is that tenants and landlords stay in touch and that they work with each other in terms of their obligations. If there is strengthening required or proposed, really it boils down to landlords and tenants talking together and working out something that's fair for both of them. But I do want to just comment on a couple of particular items that are contained in the current Auckland District Law Society lease. The first is that there's a new-ish provision in there which is what's called a no access provision. So what a no access provision means is that if there's an emergency and the tenant cannot get access to their building to conduct their business because of the safety of the public or property, or the need to prevent, reduce or overcome any hazard, harm or loss. So perhaps your building's behind an earthquake cordon, but it's not actually damaged or destroyed by the earthquake, then either party may terminate their lease by giving written notice to the other if the tenant's unable to gain access to the premises for the no access period that's specified in the first schedule of the lease. So it is important just to know what that no access period is and think about the consequences of that. The other thing that I thought is important to point out is that there are clauses in the current version of the ADLS lease, clauses 11 and 15, which talk about landlord and tenant obligations. So landlords are to keep and maintain the building in good order and repair and weatherproof, so they have some obligations to do that. And then there's a provision about access for works, so provisions that the tenant shall permit the landlord at reasonable times and on reasonable written notice to access the premises, to carry out inspection and works. But there's also provisions in there about if the tenant's business use is materially disrupted by that, what the tenant can do, and if, in the landlord's reasonable opinion, they require the tenant to vacate the whole or part of the premises, what the implications of that are as well. So the standard lease document will have some provisions in it, but it's also important to keep those lines of communication open. If you know what your obligations are and you're making an informed decision, then you can carry on and make some practical arrangements, which is really our recommendation. So that's talking about leases, and then I'll just touch on issues regarding health and safety. So when we're talking about health and safety, and there's been a lot of talk about that lately, we're talking about the Health and Safety in Work Act 2015. And WorkSafe has a website with, again, resources on it that will be useful for you. So that website is worksafe.govt.nz. WorkSafe has set out information about dealing with earthquake-related health and safety risks. So this next section uses a term called a PCBU, so that's essential vocab. So a PCBU is a person in control of a business or undertaking and can refer to a tenant, so a business owner, or the landlord, the owner of the building. So the key points around what WorkSafe is saying is that if you're a PCBU who owns or occupies an earthquake building and you're meeting the earthquake performance requirements of the Building Act 2004, WorkSafe are not going to enforce to a higher standard under the Health and Safety in Work Act. So what they're really focusing on is, are you up to date with your obligations under the Building Act? If you're not doing what you should be doing under the Building Act, the best agency to intervene will be the local council. And if you're not doing what you're supposed to be doing under the Building Act and someone is harmed, then WorkSafe New Zealand may intervene under their legislation, the Health and Safety at Work Act. WorkSafe expect you, so as the building owner or occupier, to proactively manage the risks arising from objects in and around workplace buildings on a regular and ongoing basis. And you need to keep on top of new or emerging information and ensure your workplace is prepared to deal with an earthquake. So the law says that under the Health and Safety at Work Act, PCBUs, including owners of workplace buildings, must identify and manage risks in the place of work as far as reasonably practicable. This requirement to manage risk includes risks related to the building and includes building elements. So that may be, as we're probably all aware of, parapets in different parts of the building can fall. The WorkSafe information goes on to say if the building is found to be earthquake prone, that doesn't necessarily mean that it should not be occupied. The Building Act provides a period of several years for strengthening or demolition work to be undertaken. So you will have heard about that from the previous presenters. While the risk of harm to people in or around an earthquake building is greater than an equivalent new building, this doesn't necessarily require short-term action. So WorkSafe expects you'll fulfil your duties under the Building Act when you're looking at the seismic risk. So the point there is that if you are doing what you're supposed to be doing under the Building Act, generally speaking, WorkSafe are not going to enforce to a higher or stricter standard. So again, just stressing that a building owner can't take the view that I've leased my building out, that's all the tenant's obligation, I don't want to know, I'm not going to take any action. Building owners are caught by this legislation as well as tenants, and so they are going to have to do something. And if you are on top of your obligations and proactively managing those, then that does a lot to minimise your risk in terms of health and safety. You can't take the view that by not getting a report or not knowing any information that you're safe, that won't save you in terms of either the Building Act or the health and safety legislation. So again, from a practical point of view, what we're saying is building owners and occupiers should work together. It makes some sense if you work together to identify, if you're in an earthquake building, what the hazards are, how you're going to manage those, so you're all on the same page with that. And there may be some cost savings in that as well, so you're not, the building owner's not doing one plan over here, occupier doing another, and either those plans don't gel, they cost you separately. You need to be thinking about your liability to the public and to customers. And there may also be some possible issues with your public liability insurance if you're just not doing what you should be doing to minimise the risk, so that's another thing to bear in mind. So what we'd just like to do finally is emphasise the value of information in preparation. Don't leave things until the last minute. There is now quite a bit of information around. Christchurch has been through a lot of this. So there's information and experience to be learned from. We're not the experimental guinea pigs anymore, and what I really recommend that you do is get up to date with your obligations, get some timeframes in place, and from a risk and insurance point of view, and in terms of potential prosecutions under either the Building Act or Health and Safety and Work Act, if you can show that you have been doing what you can to proactively manage those risks, then you will mitigate your risk in terms of prosecution under either of those pieces of legislation. And that's not generally what we want to have happen, and not really the emphasis at this point in time, but you do need to be working towards satisfying those obligations. So thank you very much for listening to me today, and there will be some PowerPoint slides to be sent, giving links to the websites that I've talked about today. Thank you.